Well, hey, good afternoon, folks. Bill O'Leary coming to you live here on this Thursday afternoon. And this is part of our Thirsty Thursday series for those of you that are new. And it's where I go live every Thursday, talk about things that I see in what I do for a living. I'm a lawyer, estate planning, elder law, wills and trust, and probate, and that sort of thing. So if you're thirsting for knowledge, you've come to the right place. The topic I'm going to talk about today is step up in basis and why it matters in estate planning. Step up in basis. So I'm going to explain what that really is. So there have been recent news stories that you maybe have come across talking about a step up in basis and the current administration's attempts to eliminate it or adjust it. If you're looking to engage in estate planning, or let's say you might be inheriting an asset or property, it's important to understand what this step up in basis concept means and how it might affect you. So, what is a step up in basis? Well, it's a provision in the federal tax law. It's what we call basis, and what this concept does is it basically is a way for you to determine your investment in an asset so that any capital gains tax that may be owed upon a later sale of that asset can be properly calculated. So here's a simple example. Let's say you buy an asset, maybe it's real estate, maybe it's a stock, whatnot, for $10,000. And sometime down the road, you decide to sell it for $15,000. Well, a sale has occurred, and since a sale has occurred, you can have to pay capital gains tax. But here's the question. How is that gain calculated? Do you have to pay tax on the entire $15,000 that you sold it for? And the answer is no. You only have to pay tax on $5,000, and that's the amount that the asset increased in value by from the time that you bought it to the time that you sold it. In fact, it wouldn't be fair to you to have to pay tax on that first $10,000 because you already paid tax on that first $10,000 that you used to buy the asset. Let's say, a salary or wages from your job, you pay taxes on that. It would be unfair. In fact, that would be sort of paying tax twice, and we don't like that. Now, let's say that you own that same asset, something you bought for $10,000 years ago, and now it's worth $15,000. And this time, instead of selling it, you decide to give it away, let's say to one of your kids. Fairly common thought process. Now, what are the consequences of that? Because, hey, it certainly sounds like an easy plan, right? Well, the problem is if your child, after receiving that gift of the asset, turns around and sells it shortly after that, let's say for $15,000, sort of same facts, okay? Does your child have to pay the capital gains tax? And the answer is yes, because a sale occurred. How is the tax calculated? Does your daughter have to pay tax on the entire $15,000 that she sold the asset for? And the answer is no. Again, just in the situation where you sell it, she only has to pay tax on that $5,000 that it increased in value by. Basically, she has to pay the same capital gains tax that you would have had to pay if you sold it. But that being said, your daughter has to still pay tax on the $5,000. So here's the question. Is there a way to get rid of that tax altogether while also giving that same asset to, let's say, your daughter? Well, yes, there is, by waiting until you die. Waiting until you die. Instead, give it to your daughter through your will or your trust. And so in that scenario, you see, your daughter, she would inherit an asset worth $15,000, what it's worth when you die. And let's say she turns around right away and sells that asset for, again, $15,000. That's what it's worth, right? Does she have to pay capital gains tax? No. Well, you say, but a sale occurred, so don't you always have to pay capital gains tax when a sale occurs? Well, no, not so fast. A capital gains tax has to be paid upon a sale only if there is a capital gain. In this situation where your daughter inherits an asset and let's say sells it for the same amount that it was valued on the date of your death, There is no capital gain. There is no capital gain. And the reason why is because the basis in that asset, the tax basis we talk about, okay, gets adjusted when you die. It gets adjusted to what it is worth on the date of your death. It's what we call the date of death value. And so all that sort of lurking capital gain, that built-in capital gain that would have to be realized if you sold it while alive, or if you gifted the asset to a child and they sold it, all of that goes away, okay? So that's why we call it a step up in basis, because the basis gets stepped up to the value when you die. Now, to be technically accurate, we really should be saying that the basis gets adjusted to the value on the date of death, not that it gets stepped up, because it could get stepped down if the value of the asset has gone down from the time you bought it to the time that you sold, or the time of your death. Think back during a period of recession where real estate dropped in value, someone dies with that real estate. The recession we had 15 years ago, there were a lot of folks that had to deal with a step down in basis, okay? But that being said, it's sort of common sort of a parlance to say, hey, step up in basis, and that drives home the point. So the moral of the story, if you want to pass on an inheritance to your family, and you've owned assets for a long time that have gone up in value, you might consider holding them until death and passing them on as part of your legacy. So if you'd like to know a little bit more about the step up in basis and why it matters in estate planning, and maybe how we can help, we would encourage you, in fact, invite you to schedule a free 15-minute phone call with our team. Just go to our website, legacyplanninglawgroup.com, and there's a button there that you'll see very quickly called Schedule a Free Discovery Call. Click on it, takes you to our scheduling calendar. Pick the day and time that works for you. We'll jump on the call with you and basically start a conversation. So, by the way, again, just as a reminder, that call is complimentary. If you've enjoyed this video, we'd ask that you like it. And hey, subscribe to our YouTube channel, Legacy Planning Law Group. We have great videos. We're putting together new ones every week, every month. Keep putting more of them on there. I think you'll enjoy them. So hope you have liked this. Hope you will join us again next Thursday for our Thirsty Thursday series. If you are thirsting for knowledge, we will quench your thirst. Bill O'Leary signing off for now. Go make it a great day and a better world.